Hi, good morning. All right, everyone, I'm going to call the docket. If you are here, please let me know that you are here. We're going to start our jury trial this afternoon. So those cases that are not taken care of, you will be here for jury trial this afternoon. To all those people, when I call your name, please, I'm sorry, I need a mic. Here you go. Thanks. You know what? I think something wrong with this thermostat. It says it's 69 degrees in here. No way. It's not 69. No. All right. Yes.
For the jury, one jury.
Okay. All right. Rosa Tovar. Rosa Tovar. And to everyone who's on the front row behind the attorneys, if you could keep that row clear, please. Thank you. Zachary Warren.
Justice President, I'd like to approach up to Dr.
Thank you. Andrew Prado. Andrew Prado. Again, everyone, if you don't let me know you're here, I'm going to assume you're not here and a warrant will most likely be issued for your arrest. Jose Sanchez. Jose Sanchez.
Council President, I'll reach out.
Thank you. Mary Diaz. Thank you. Edward Gill.
Your Honor, he's not here right now, but I'll approach you next minute, please.
Okay. Julius Clayton. Julius Clayton. Jesse Esparza. Charles Jones. Richard Thomas.
Vice President Council, Your Honor, we're ready.
Thank you. Mcdelia Salazar.
Here.
John Carlo Armstrong.
President, Your Honor.
Priscilla Sosa.
Here you go.
Alejandra Black.
President Council, Your Honor.
Calvin Johnson.
Council is present. I spoke with him yesterday. He should be on this list.
Thank you. Calvin, he's on the docket twice. Alan Hernandez. Thank you. Crispin Valle. Thank you. Joseph Murrow.
I am present for him. I do not see him, but I can give him a call.
Oh.
Are you Joseph Murrow? All right, thank you.
Thank you, Judge.
Danielle Gomez. Danielle Gomez. Michael Herrera.
Here.
Valentin Ramos. All right, sir, you need to find a seat. Rudolph Montoya.
He's here.
President.
Thank you. Isaac Chavez. Isaac Chavez. And these names may be a repeat. Edward Gill.
That's fine, Your Honor.
Okay. Matthew Burke. Jesse Esparza Jr. Thank you. Richard Thomas. Thank you. And Mary Diaz. All right. The names of the persons who are in custody, their names were not called. Their names will not be called. Attorneys, if you need your client and that client is in custody, just request it from the deputy. Is there anyone here whose name was not called? Yes, what is your name? All right, you need to stand up. What is your name? What did you say his first name was? Hector Hernandez. All right, you need to speak loudly for someone who has an allergy ear. That's me. Anyone else whose name was not called? All right, attorneys. I know people do not read a lot because you all receive a lot of emails and a lot of things to read. But there's a sign to my left, and it says that when you want to approach the bench, just let the clerk know. The clerk will place the file here, and I will call you in the order that I receive you. But I'm trying to keep the well of the court as clear as possible for the deputies, for security, and also so that we're not bunching and on top of each other. And if you find the courtroom is too hot, then you need to let the powers that be know that it's too hot. I have no power on changing that. There's a thermostat. That thermostat does absolutely nothing. So if you have a problem with the heat, please report that if you feel the need to do so. All right, everyone, today is Tuesday. Let's not turn it into a difficult Monday. Let's make this a happy Tuesday, and you all may confer.
What would you, please?
One case, 2019, 86. Judge, real quick, I want to show you something.
Yes.
Guess where Rachel is?
Where?
Madrid.
Okay.
And then she's going from there to the Amalfi Coast with her friend. She has a friend. She's like, I'm doing the Virginia trip.
Okay, I'm gonna have to talk to her. How long is she?
She got there on Thursday in Madrid, and they're going to spend a week, and then they're going to Italy. So she has a friend who's like a Fulbright scholar, who's been teaching English there.
Uh-huh.
So this is at the Prado, like that really famous art museum.
Uh-huh.
And I'm kind of pleased that my daughter went on vacation and actually went to an art museum, and she recognized some of the names. I'm like, my education money was well spent.
Well said, yeah. Oh my gosh, I'm gonna have to message her so she can send me photos.
Oh yeah, so that was at the Picasso Museum.
Oh wow.
And I told her, I said, go see the painting Guernica. And she said, I went and looked. It's spectacular. She goes, and when they flew it back from the Met, it was like on a passenger seat on Iberia Airlines.
Oh my gosh.
So I'll tell her to send you pictures.
Okay, awesome. Oh, that is good.
What did you want, Ryan?
I get some file facts there for Alejandra Black. Thank you, ma'am.
So, with basically my understanding, it's still like a level of yeah, that.
Is that no reason they
Yeah. From my understanding.
Well, I see it there.
Facebook is not one. We regularly, Tuesdays, fact find. They're trying to. They won't. They won't skip it. So law enforcement portal, they want to. My understanding.
All right, Edward Gill. Who are the parties on Edward Gill?
Right here, Your Honor? Or-
Oh, no, there's a line there. Yeah.
Oh,
Everybody always wants to pass the space.
that was a dumb question.
Michelle's on, but Michelle's more aware of what's going on in that case. Can I go try to find her real quick?
Oh, no, we can, Mr. Cisneros, do you mind waiting just a little?
I'll wait.
All right, thank you.
That's the same with mine, Judge.
Okay, all right, thanks. And who is yours?
It's on Zachary Warren.
Okay, thank you. All right, who is here on Alejandra Black? All right,
Stop here, go there.
oh, no, that's the line.
Okay.
Yes. Yes, what is happening with Mr. Black?
Just spoke to the state. They're still trying to figure out contact information for the planning witness.
All right, let me see what page he's on.
Should be fairly far back. It's our first setting.
Well, thank you. Brenda, I missed you doing that. Mr. Black, need to come forward. Who's the prosecutor you confirm with?
So I've spoken with Ryan on it in general, but I spoke with her this morning.
All right, what is going on?
No.
Are you asking me?
Yes.
Okay. Judge, we've requested contact information from our investigator on the victim. The number we have in the police report is inaccurate. So we're requesting 30 days to contact, attempt to contact them.
Yes, one moment. All right, we're gonna come back on July 12th.
Thank you, Your Honor.
You need to get a reset form.
Okay.
Judge Michelle's back.
All right, just give me a moment.
So,
Yeah.
All right, the party's on Mary Diaz.
she's not. The picture you have to come in.
Okay, I don't know, why was this put up?
I put a motion in there, Judge.
Okay, all right, thanks. Okay,
That was mine.
all right, hi, and this is Richard Thomas. Can you put that back? Just don't put it up here until the attorneys, the defense attorneys ask. Oh, no problem. Mr. Gill, Edward Gill.
Your Honor, late yesterday afternoon, I put a motion for continuance because my client's wife, they had to induce labor on her yesterday and the baby was born, I think, last night. I did tell my client that I need him, if you don't give us a continuance, that he needs to be here within an hour after you tell us what time to be here.
Okay, he needs to.
And
be-
we're number one.
Yes, so he needs to be here.
Okay.
All right, thank you.
Judge, may I approach him, Mr. Warren?
Just one moment. All right, who are the parties on Zachary Warren?
I am Judge.
And where is Zachary Warren? You need to come forward, sir.
Come on, Zach.
All right, there should be 2 cases on Zachary Warren.
I believe it's only one.
There was just one, Judge.
Okay.
It was, it pled to a reduced offense.
Okay. All right, are you all ready to plead?
No, Judge, I had spoken with Michelle yesterday. We're set for sentencing. I've been trying to get a risk assessment set up with Zach, but the guy I use for assessments is retired. So I was just gonna ask the court for another couple of weeks so I can try to get it set up and get that done. We'll be ready to proceed. It should not take very long.
And Judge, the state's ready. Given the fact that we got late notice of this, our witnesses and family members came to court today because we didn't know what was going to happen. So they made the trek from Fredericksburg. They're already here.
Okay, how far is Fredericksburg from their county?
That's
think-
65 miles.
65 miles?
I believe so. Takes about an hour.
All right, can I have the family come forward? Who are your witnesses on Zachary Warren?
So Carissa Borlace is one of our witnesses, and I'm not sure who all came to court today.
All right, who are the parties who came to court?
They're in the waiting room.
All right, so you can have them come up.
Okay. Judge Carissa will be down here in just a second. Colton came down here as well, but he has a baby with him, so he's.
Okay, all right, I just wanted them in the courtroom so I can explain. I'm a firm believer that communication is key. And it's when you don't have communication that things tend to break down and people don't understand. So I want to make sure that everybody understands what I'm going to do. Ms. Ferguson, Mr. Black has been reset for July 12th. Is that, if that's not a good date, just let defense know. You're welcome.
And we did reach out to them last night about defense's motion, but, you know, obviously they feel that it's important. And we feel it's important for them to come, so
Okay.
they didn't want to risk it.
No, I appreciate everyone being present.
Oh,
So,
Oh, yeah. I just said it there, so there wouldn't be any confusion. All right, so that's the party.
yes.
I'm just gonna have my client step over here.
Okay, sure. Oh, no, they don't need to come forward, just be in the courtroom. All right. So, Mr. Mauer, you're stating, could everyone please whisper? Mr. Mauer, you're stating that you have an expert that you want your client to see. to
Yeah,
provide
Judge,
information to the
I
court?
want to have my client do a risk assessment as for purposes of letting the court know about any risk of reoffending. And the person I use, Michael Watkins, retired. So he's given me a couple names to talk to, and I should be able to have it done. It's not a very lengthy process. Well, it's basically interviewing some testing. So if the court would see free to give me like 2 or 3 weeks, I think we can have it done and be ready to go.
All right. So to the family members who are here and people who are here, I know that when you come to court, you expect a hearing to take place and you want it to take place because you've traveled for it to take place. But both sides need to have an opportunity to present whatever information they want to present to the court. And that way, when I hear things, nobody can say, I didn't hear everything that they wanted me to hear. So, Mr. Mauer, I'm going to give you a 2-week reset. Will that be done by then?
Yes, ma'am.
All right, so we're going to do a 2-week reset, and then at the next setting, we're going forward.
Yeah, and Judge, if for some reason we can't get it done, we'll be ready to proceed anyway.
All right, and the results you receive, if you could tender those to the
Certainly.
state. And if it's done before then, and you're able to tender it to the state before then, please do.
We'll do.
All right,
And Judge, just for the record, state's ready to move forward and we'll be ready to move forward at the next meeting.
all right. Oh, well, we're not on the record. You want us to put it on
So,
the
no, that's
Yeah.
okay.
We can put everything on the record. All right, Ms. Ferguson. Can I have a 2-week reset on this case for sentencing?
30th is fine. I'll be in.
All right, so we can do it June 30th. How many witnesses are you expecting to have witnesses for testimony?
Just a couple maximum for the state.
All right, and you're expecting
Probably 3 or 4.
probably 3 or 4. So when do we want to set this, Ms. Ferguson? All right,
That's fine.
so June 30th at 1:30. All right, and you're aware of my schedule though with. Because I have the meeting, the bail bond meeting at 2 p.m. and I don't want to miss that. We could start at 1:30, but usually those meetings take about 10 minutes. So is it possible for us to do it maybe at 2:30?
Yeah, that's fine.
All right, so it's going to be June 30th at 2:30 p.m. And that will be the last reset.
Thank you, Judge.
All right, Ms. Ferguson will give you a reset form. All right, Rudolph Montoya. And Brenna,
Yes.
what page is this? Okay, there he is. All right, we are here for discovery. And let me see how long we've been doing discovery, because, yeah, we've been doing discovery since July 22nd, 2021. So this is our last day for discovery, and whatever discovery issues anyone has, then you'll need to subpoena people. So what's going on?
So I was able to confirm with Mr. Gross today about, he attempted to subpoena records through both Facebook and Sprint, AKA T-Mobile. And I was able to confer with him today to kind of narrow down the scope of what he's looking for, because he hasn't been able to get any of the items he's been looking for. I told him, in an effort to help facilitate getting this information, although it's not within the state's possession, I would have my investigators start working on these items today, particularly as it relates to both Facebook and T-Mobile, aka Sprint. So that's kind of where we're at today, Judge.
All right, so state, have you made an offer?
I believe we have, Judge.
Has an offer been tendered?
Because discovery is ongoing, I don't think we've talked offer yet, but I could be wrong on that. I don't want
I have to
to
double check, Judge.
mistake.
All right, Ms. Ferguson, on Mr. Montoya, recall this in 2 weeks, and at that time, the state will present you with an offer. And then after that, I'm going to give you your plea deadline date.
We won't have the discovery by then, Ron.
Here's the thing, Facebook, T-Mobile, Sprint, this has been going on since July 2021. We are where we are. If at some point, T-Mobile, Facebook, Sprint, what do we do if 2 years from now, Facebook, T-Mobile, and Sprint don't have discovery for you guys?
Well, that's not our fault, Judge.
I know.
And to have a fair trial on a continuous sex assault of a child case, I've got to have that discovery.
Yeah, and
And
what
the
if it doesn't
government agreed to
exist?
help with it.
What is if it doesn't exist?
It exists, Judge.
Okay. All right, Ms. Ferguson, can you recall this in 2 weeks, please? State should attend an offer in 2 weeks.
Yes, Judge.
All right, we'll be back on June 30th. At that time, the state will tender an offer to you.
Yes, Judge.
And then what does that actually mean, Judge, as far as,
Oh, after they tender the offer to you, when we come back on June 30th, I'm gonna give you a plea deadline date. And then after that, we'll move towards jury trial.
well, what if we don't have discovery by then, Judge? Can we revisit that?
You all need to subpoena whomever you need to subpoena.
We've
Have
done
them
that,
come.
Judge.
No, I mean, have them come into court.
They
I mean-
refuse to comply with the subpoena.
We'll take that up when we get there,
What date is it you're looking at, Judge?
June 30th.
Well, how about this then, Judge? If I file motions to depose some witnesses? I mean,
Okay.
that'll fix the subpoena problem.
All right, you can file whatever you wish to file.
Well, what I
Mr.
don't want to have
Gross.
happen, Your Honor, is be in a position with you where you think I'm being dilatory or something. I don't want that to happen.
No, I know
want-
you guys are doing, we've had this issue with Facebook before. I mean, but I'm not gonna have a case staying open. We're here in, July 2023, and we're still talking about Facebook or other discovery. I've had this issue happen before, and I've told the state and I've told the defense, you want to have a hearing for discovery and subpoena those people to be here in this court on that day for a discovery hearing, I'm more than willing to do that and have it heard. But I'm not going to continue to have a case out there forever. And we're still, 2 years from now, we're still trying to get discovery from Facebook, Sprint, and T-Mobile.
Well, I know it's possible because I'm working on a Williamson County case where they got 27,000 emails and Facebook pages. And based on that, they were able to put a defense together. And that's gonna take me time to get those documents in and then review them.
Okay. All right, I'll see you back on June 30th.
Is that something the court then would consider?
I'm
Your
always
Honor?
open to looking at everything.
Okay,
I'll see y'all back on June 30th.
okay.
All right, make sure you get a reset form. Richard Anthony Thomas. All right, who's here on Richard Thomas?
I am, Your Honor.
All right, where's Mr. Thomas? Oh, he needs to come up.
It's a state motion for continuance, Your Honor.
Okay. All right, Brenda, we're on the record. Court is calling 2021 CR 4470, State of Texas versus Richard Anthony Thomas. Could I have parties announced for the record for the state?
Michael Villarreal, for the state.
For the
We are
defense?
biased on behalf of the defendant, Your Honor.
All right, and are you Mr. Richard Thomas?
Yes, ma'am.
All right, state has filed a motion for continuance. Defense, have you had a chance to review the state's motion?
We have, Your Honor. We are opposed to it. That's what we're in front of you.
All right, state.
Yes, Your Honor, there's two particular witnesses that we've just been able to recently have contact with. The most important one of those is the first one listed as Belinda Castellanos. She was formerly with CPS, but she's retired, but luckily, as of last week, I believe it was Friday of last week, we were able to finally get a hold of her. And she was on her way already out, or the next day was leaving out of town for vacation. So we were unable to subpoena her. She's a material witness in the case, is demonstrated in the motion for continuance. The defendant in this case has signed what I would characterize as a confession in front of her, and she would be the necessary sponsoring witness to admit that. The other witnesses that are unavailable is Sabino Martinez, who is a polygrapher. And obviously, we're not attempting to introduce the polygraph exam, but really the interview, the post-interview of the polygraph exam, in which the defendant also admits, and this is previous to the confession to Ms. Castellanos, that he did have sexual contact with the complainant, but did not go into further details. And so both of those witnesses are material to the state's case. We're asking for continuance based on their unavailability.
All right, when is the person, Miss Belinda Castellanos, when is she going to be here?
So she's out all of this week and all of next week, but then returns after that.
Your Honor, my
No,
response.
well, no, I'm not finished. It says that she's expected to return back next week in your motion. I'm not talking, the second person,
Okay.
Sabrina Martinez, you said that they will be back on June 17th,
which is Friday.
which is Friday. No, I mean, the first witness. So the first witness will be back next week. Because
Yes,
that's what the
Judge.
motion-
Yeah, so all there, I'm sorry, she's out all of this week. She left last week, end of last week for her vacation.
So will she be back on Monday?
If Marina could come back, she's the one who spoke to her. If I could
All right,
just-
let's find out if she's gonna be back on Monday.
Okay, thank you, Judge.
You're welcome.
Yeah, may I respond or?
Just a moment.
Okay.
Judge, I'm sorry, I'm trying to get a hold of Marina.
No problem. Can you have a look at that? I think that was an affirmative finding.
Judge, if I can just get a couple minutes, let me go physically find Marina real
Sure.
quick, just to ask her.
No problem. If you want to have a seat, and then we'll continue. Yeah, I think it was an affirmative finding. of family life. Oh, definitely. I did. Okay. Thanks. Oh, and this appeal was denied. Oh, yeah. Okay, thanks. And this one too. Okay. All right, the parties here are Mary Diaz. And Ms. Diaz, if you can come forward, please.
Judge, I think Michael had actually filed a motion on it. He's been working on a lot of the discovery, but he just stepped out.
Okay, all right, we'll wait for Mr. Villarreal to come back.
Okay.
All right, you can have a seat. Joseph Morrow.
Yes, Judge. President, do you need Mr. Morrow?
Yes.
Judge, Mr. Morrow is deaf. Just so you know.
Okay. Well, I don't speak sign language.
He would read your lips.
No wonder he did not hear me this
Yes.
morning. All right, so for anything to happen, we'll make sure we have an interpreter.
Okay.
So, Ms. Ferguson, you put a note in the system that Mr. Morrow will need an interpreter,
Yes.
and I'll try to look forward. So, what is happening with this case?
Judge, there's an ethical disclosure issue on one of the officers that I need to look into. It's my understanding that he's under investigation for a crime, but I need to figure out exactly how that affects this case. If we could get a very short reset, maybe 2-3 weeks, I think I can have a resolution on this case.
We don't have any objection to that. I would prefer 3 weeks. I'm about to go into a 2-week trial on the 437th. So,
Okay, all right, I can give you all a 30-day reset.
Great.
okay.
All right, and when is your trial on the 227th?
In the 437th, it starts the 21st.
All right, when do you anticipate that'll be concluded?
It'll take 2 weeks.
All right, so Ms. Ferguson, can I have a 30-day reset on Mr. Morrow? 30 days.
The 19th of July. So
Yes.
July 19th. Okay,
And they
same
will
place.
give you paperwork.
Okay, so just have a seat. And I'll-
And Ms. Christian did not recognize you.
I know, I'm sorry, Judge. It's the pattern.
It is, but the pattern is beautiful.
Thank you.
Carol. Carol. Yes. And I talked to him yesterday. He said that he called me and said that he had another cases. He had other cases. So he said that he would see him. Yeah, he said that he would see.
Yeah.
Okay.
On rate or whatever.
Yeah, on RAF. That's fine. Yes. Can you let him know who is up? All right, Mr. Debnat? Can you come forward, please? Mr. Devnap, you have an appellate counsel that's been appointed to represent you. His name is James C. Long. He will be contacting you at the jail, okay? All right, thank you. Yes. Mr. Villarreal, do you have information?
Yes, sir. So she should be back Monday.
All right.
Monday's a
let's-
holiday, just FYI.
All right, we're coming back on 2021 CR 4470, State of Texas versus Richard Anthony Thomas. All right, so we're back on the record. And state, when will Miss Belinda Castellanos be available?
So she's coming back on Friday, so she'll be able technically next Saturday. And so next Tuesday, which I believe is, because Monday's a holiday, she would be available to testify.
So she'll be back on the 21st.
My calendar, sorry. Yes, she.
All right. So, and how many witnesses are you expecting to call in this case?
It should be 4 or 5 witnesses.
All right.
Total.
And defense, Dr. Pachonis, 5, but how many witnesses are you expecting?
I have about 12.
All right, so this is what we're gonna do.
Judge, may I respond? I'm sorry. It's just my client is opposed to the motion.
All right, court is gonna deny the motion. What we'll do is if your case comes up for trial, we'll start trial and we will continue it on the 21st for your witness to be here.
Okay.
So the motion has been denied.
Yes,
Thank you, Judge.
you're welcome. And just keep that available.
No.
All right, court is calling 2020 CR 11865, State of Texas versus Mary Diaz. Can I have parties announced for the record for the state,
Michael Villarreal, state.
for the defense?
James Toshin from Ms. Diaz, Judge.
And where's Ms. Diaz? Why is she being hesitant about coming forward?
It's a little slow today, Judge. Forgive her.
All right. Nothing to forgive, Mr. Toshi. I'm just asking questions. I love, as you know, I love information. And if someone's moving
We
slowly.
prefer to ask for forgiveness than permission, Judge. So.
Oh, see, don't ever do that. All right, so the state has filed a motion for continuance. They say that there is outstanding discovery issues, which I'm wondering, how can that be? Because I'm looking at the docket sheet. And on the docket sheet, I have from June 30th, 2021. State gave a disc to the defense. July 21st, 2021, all discovery received. An offer was due on August 26, 2021. We come back on August 26, 2021. I asked, has all the discovery been received? And it's like, yes, it has been. So we come back on September 30th. It was recalled for October 26th because attorney was ill. And then we came back on what is this? December 1st. Again, has all discovery been received? It's like all discovery received and offer tender. And then I did a plea deadline of December 15th, 2021. And on December 15th, 2021, I have the state to speak with complainants. So we recall back on January 14th, 2021, a new offer was tendered. A request was made for the plea deadline to be extended. I did it. And again, I asked, has all discovery been tendered? And the answer was yes. And so we came back on February 28th. And February 28th was the plea deadline date, and that deadline date expired. And then again, I said, has all discovery been received and offer been tendered? Yes. And so we would come back on April 4th, 2021. And the jury trial is set for today. So now I have a state's motion for continuance, and what is going on?
So Judge, as you're aware, I only came into this court in January, and so I've adopted this case, and I have done a thorough review of the case to ensure that all the discovery that is mentioned or alluded to with any report or document or item that is within the state's possession, meaning within my office's possession, was tendered. And so in reviewing that, I have been working with the detective on this case, who understandably is a little overwhelmed with the recent spike in homicide cases. Regardless, I've been working with her to diligently get this information. And a lot of this is substantial information that was never turned over to the state, as far as I'm aware. Those include voluminous bank records, which the relevance in this is, I can explain the relevance if the court wishes.
Yes.
The relevance of the bank records is that the victim, the deceased in this case, was found days after the murder, and the bank records, the state believes, will demonstrate that the defendant was in possession of bank accounts and cards related to those accounts and was using those accounts. And so that shows that the fact that she had these cards and just even after the death was using this despite her not even being on the decedent's accounts. And so those are the relevance of those particular bank records. The other things I think that are listed within the motion are a little bit more obvious, like EMS records, crime scene search reports.
I don't understand why EMS records have not been turned over. I'm assuming the EMS records is related to the complainant.
Yes, Judge.
I'm just stunned by that.
I can't.
And I realize that you were not previously in this court, but I'm just stunned by the EMS records when this is alleged to have been a murder.
I understand that, Judge. I can't speak for my predecessors who had previously had this case. And what I can tell you is that I've done what I have been able to do in the short period of time that I've been in this court in order to get this case ready for trial. Some of these items I wasn't able to get until last Friday, which is a big part of what needs to be turned over. Some of these items are still outstanding, and I'm trying to meet with the detective. Part of the problem is that one of the crime scene, the uniformed evidence detectives, is no longer with SAPD, and so trying to backtrack her steps in order to find discovery that the detective doesn't have as well. And so I understand all of these issues should have been resolved prior to today. But unfortunately, I'm in this position today asking for the court to give me some more time in order to fully comply with my discovery obligations under 3914. And I'm just being candid with the court as far as what I don't have and why I don't have it, and that I intend to give it to Mr. Tochi as soon as possible.
All right, defense. Do you have any objections to the state's motion?
I don't. I've discussed it with Ms. Diaz, and we don't. And you know, obviously, I'm in the position of not really ever knowing what's out there. It's not like detectives communicate with me, and so I rely on them.
But everybody should have known EMS records.
Well, absolutely.
I mean, some of this I can understand, but the EMS records, the crime scene sketch, that I don't understand. 911 audio recordings.
And you can glean, oftentimes, it's a very voluminous file, that there are certain things and certain items that are missing, and then some things just would never occur to you. And so I would rather have all the information than not have it, obviously, Judge. And it is going to be, if it eventually gets tried to the court, it is going to be a very long trial. I can assure you of that. So having said that, I'd rather obviously have the information to see if there is anything exculpatory or useful for me as well.
And Judge, what I could tell you, as far as the discovery acknowledgement, I pulled it yesterday to see how long the index was, and it's 29 pages. And so, as you can understand, it took me a very long time to get through this file.
All right, Ms. Ferguson, on Mary Diaz. Are we able to put this down for a jury trial? The week of July 18th, is that possible or no? Or either the week of the 25th?
I have a notice, Judge, that is right around that time for July. It's been in for about 4 months now.
What are you doing?
In July, we're going to Maryland for a whole week.
With your family?
Yes, ma'am.
Do they want you there?
Probably not. If I can get out of it, if I can feign illness.
All right, if PQ privately texts me and says, don't let Jim go, I'll be hard, and I'll be like, no, you can't go.
Let me think about
What
that.
is it?
Let me think about that.
What are your dates?
I believe that,
Do you need to call PQ and ask?
no. We have, I'm at the end of the month, June, July, and August, and I believe, I need to look. I do.
All
I mean,
right,
I have a
let's-
notice on file, whatever the days are on the notice.
All right. Ms.
It'll tell you,
Ferguson,
but it's like 26th, 7th, or 8th through August 3rd, 4th, or 5th. It's something like that.
6:30 to 7:05, 8187 and 820.
Okay, so it's August 1st. I thought it was the last week of July, so it's August 1st.
Okay, so it's in August.
Yeah, but this trial undoubtedly will take minimum couple of weeks. It's going to be that.
But if we work on Saturdays and Sundays.
I've suggested that. Everyone laughs at me. I'm cool with it.
Yeah. I know you're not cool with
I
it.
mean, I hate having to get away from my family, but duty calls.
All right, Ms. Ferguson, what dates? Because we do have all days in here, so. And not to give away anyone's strategy, but how many witnesses do you expect to call, Mr. Choshin? Just a ballpark.
4 to 8.
Okay. Okay. Don't we have other things in October? And what is case is that? And that needs to go. What do we have in September? Okay. I know there's. Okay. Okay, and where are the capitals?
The capitals are.
Okay.
That's what I'm saying.
Norma? We can, and it's October, the week of October 3rd, is that Family Violence Week?
October 3rd, yeah.
All right, we'll do October 3rd. All right, Brenda, we can go back on the record. All right, the court will grant the state's motion without objection from the defense. This trial is going to be rescheduled for October 4th. Ms. Ferguson, I do want the date before then, because I want to make sure that all of this discovery that's in this motion, which Mr. Villarreal, I know you will get it to them as quickly as possible, but I'd like for us to stay on schedule and to receive updates. So our jury trial in this case is going to be October 4th at 9 a.m. I'm sorry, you'll be here at 9 a.m. Do you want them to come in on October 3rd, Norma?
Yeah, October 1st.
All right, so you guys are going to be back on October 3rd, but the jury trial will actually take place on October 4th because that's the date we've been giving jurors. Now, Ms. Ferguson, I want a date for them for discovery. Let's do it. You're going to be here July?
Parts, yes, ma'am.
All right, so let's
Yes.
set this towards the end of July, but not so close that he doesn't have time to pack, even though I know he's not going to be the person who's packing.
Yes.
All right, so we're going to come back on July 21st. And say, will that give you a chance to get all the discovery to him?
Yes, Judge, I anticipate that I'll be able to finally meet with the detective in person, actually go through the physical file to ensure that we do not do this again.
All right, so July 21st, we're going to meet for the discovery. And you can make sure that you put these dates in the reset form. And then your plea deadline date will then be extended to October 3rd.
Oh, good.
Yes. So October 3rd is your plea deadline date in your jury trial. Your client seems very happy about something, Mr. Tochi. I don't understand why.
Well, she's not terribly eager to begin trial today, and so that might be what it is.
All right, we will see you on July 21st at 9 a.m. for discovery. And we will see you for your jury trial date on October 3rd and your plea deadline date on October 3rd.
Thank you, Judge.
Thank you,
You're
Judge.
welcome. Yeah. Calvin Johnson. Good morning. Who are the parties on Calvin Johnson? All right, what is happening with this case?
Judges is set for discovery completion. One of the cases that he has from the alleged victim, I have not received the audio statement as of yet. My computer crashed yesterday, so I wasn't able to see if they downloaded it since the last time, but I do not have that. But everything else I believe I've received.
Okay, so my understanding is that the discovery was received in 2022 CR 2945.
Correct.
And no discovery had been received in 2022 CR 2946.
Correct.
All right, so is the only thing missing in that case, you say, is some audio?
Yes, it was an audio statement of the alleged victim.
Judge, I have Veripic pulled up on another case. I'll check and ensure that it's on there. I just told defense, if not, we can get her a copy or make sure it's uploaded. And I provided my email address if she discovers that she needs anything else.
All right, so Ms. Ferguson, on Calvin Johnson, can I have a 2-week reset for discovery? And at that time, I'm gonna want a discovery acknowledgement.
Okay.
I can do 30th or 28th.
All right. June 28th or June 30th.
is fine.
All right, we'll come back on June 30th. And that will be for discovery, and I'll need a discovery acknowledgement.
Okay.
All right, thank you.
Thank you.
I just get a reset form from Ms. Ferguson.
Thank you, Judge.
You're welcome. And Ms. Tibbs, yes, can you make sure that your client is on time next time?
Absolutely.
Thank you. Michael Herrera. Good morning. This is for jury trial.
Well, I don't believe so, Judge. If you recall, this is the one yesterday that you recalled for today because of the short notice I got of the setting. I think I received it on Saturday, but I didn't see it and I didn't tell my client that he had to be here because I didn't receive that. There's still, I believe there's 3 advocacy center videos that I need to review and schedule a time to go to the district attorney's office to review those, Judge. Wasn't able to do that because of the short nature of the notice, but I will get that done as soon as possible.
Okay, so is that the only outstanding discovery?
I believe so, Your Honor. There was something mentioned in the file about possible another incident involving another person. We haven't been able to obtain any more information about that at this point in time. But as far as the actual discovery we have in our possession, I believe that's the only issue.
We did receive CPS records that the state turned over upon before granting an order previously.
All right, and so the other, well, possibly another incident involving someone else.
Yes, someone else.
What is the status of that?
So we'd reached out to that person's mother to see if we could get more. I don't imagine that a separate offense would come with that. It's just something that could come into play under. And again, I don't know if there's a basis for it or what the facts are exactly. It's something that the victim had mentioned, but possible punishment or possible 3837. I don't anticipate another indictment coming down.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Herrera? And that 30-day reset is to make sure that all discovery has been received. And if it's been received, then state you need to be prepared to make an offer to the defense on that day.
Okay.
All right, so we'll be back on July 21st. And at that time, I'm going to want a discovery acknowledgement and state to make an offer.
Thank you, Judge.
All right, you're welcome. Just get a reset form for Ms. Ferguson. Could I see the file on Matthew Burke, please? Matthew Burke. All right. Good afternoon. Well, good morning, Mr. Burke. Mr. Burke, we're recalling your case for tomorrow. Ms. Ferguson will give you a reset form. Your attorney is not present today. All right, thank you. Just get a reset form from Ms. Ferguson. Yes, tomorrow. Yes, yes. I understand that we don't have, we do a full day, but I don't know where his attorney is. All right, can I have the parties on Valentin Ramos? Valentin Ramos. Why were you not present for court?
I was told it was a 9.
I'm sorry, what?
I was told that my court date was a 9.
Right, Judge. It was at 6/7, but we both were under the impression it was 6/9, and he figured it out at 6/8. So Norma reset it for today. But the reason they give you the file is he's applying for pretrial diversion, and we just turned in the application.
All right, state.
Yeah, Judge, that's accurate. We just offered BTD today.
All right, Ms. Ferguson, can I have a reset date? All right, we'll see you back on July 18th. Make sure you do everything with regards to PTD. You need to get a reset form. PR. No. Anthony Davis.
I'm here, Judge, on Mr. Davis.
Yes.
I think I just need to clarify a few things from yesterday.
Yes.
So I think he has 8 cases total. And so right now, the state has made their offer and it involves pleading on 2 of the misdemeanor cases. The county court 7.
All right, everyone, please whisper.
So the misdemeanor case that he needs to plead, it's a DWI in county court 2 and then an ABI in county court 7. I talked to a coordinator in 7. We're scheduled to do that plea tomorrow. However, the county court 2 case is a little bit more problematic because they haven't, he's on the list of cases that are going to get shuffled out of that court. And I checked in with the clerks in county court 5 yesterday, and they said that shuffle has not happened yet. And then I think as part of the plea, he was going to go to lifetime recoveries. And then I spoke to the admissions director yesterday, and she said that they would have a bed available the first week of July. And so it's more of a logistics, I think, issue with Mr. Davis.
All right, state. I have someone from the state on this case with Davis. So I don't know what the issue is or what the status is in county court. So it appears that this is going to be out here forever. So because my understanding is that cases have not been transferred. Is there a judge in county court today?
Today it was Judge Harrell, I believe. Well, it was Judge Harrell yesterday, and I saw him walking that direction. So I.
All right. So why don't we do this? Why don't we go speak to Judge Harrell and see if we can take this?
I believe the cases may have been transferred last night, so I'll double check on.
All right. So, but if Judge Harrell is there today, if you could go down to Judge Harrell and see if he can do these pleas today, because he may be able to do that. And since we have your client here, it will just take a matter of the deputies transferring in.
To county court 5.
Well, county court 2.
Okay, the county court 2. So I think we are set on that plea in county court 7 also tomorrow.
Okay. All right. So just see if in county court 2, if there's a judge there, and if it's Judge Harrell, I'm sure he would have no objection to doing these pleas for this one. At least the county court 2 will be out of the way.
So I think Judge Harrell was in county court 5 yesterday because I had gone there originally to talk to Judge Longoria to see what the status was. But I can check online, Judge, and see his case may have been transferred last night.
But here's the thing. If you go down to county court 2, whether it's been transferred or not, And if there's a judge there, and if Judge Hall is there, I'm sure he will take the plea today. And they will bring those files back to County Court 2 and take the plea today.
Understood, Judge.
Yes.
I think what I was trying to communicate was that I believe Judge Charles in County Court 5 today.
All right, Norman, can you call County Court number 2? Because nobody appears to want to call County Court 2. Can you call County Court 2 and see who's the judge in County Court at law number 2 right now? Yes. All right, thank you. And then we will go from there.
Now I understand what you were saying.
No problem. Isaac Chavez. Isaac Chavez.
I'm here on that, Judge.
All right, where's Chavez?
So it was a motion to release I think there was a weapon in this case, and so I just filed a motion, and Norma wanted me to approach in regards to that.
Yes, have you spoken to the states?
I have not. I filed it before everything else happened.
Okay, no problem. If you want to speak to him about this motion, then I'll take it up.
Okay, thank you.
All right, thank you.
I didn't serve that.
Okay. Okay, all right, just recall it. Okay. There you are. Yes. And Carolyn, if you need to sign anything else, just let me know.
Judge, I have an update on Mr. Davis.
Yes.
According to the list that was sent out last night, his case has been transferred to County Court 8.
Who is number 8?
Judge Roman.
All right.
I believe she's in today, so I may be able to also take care of that.
Okay, let me just, if you have no objection, I'll text her and see.
If I don't have any objections.
Okay.
Anything to get anything done.
I'll be right back. And can you, Caroline, are you gonna sign these for me? Ms. Peterzak, on your case?
Yes, sir.
I went to the court and it appears on the system that you filed a motion to have him evaluated.
I believe he was already evaluated. though, Judge.
Ms. Ferguson, you find out from magistrate court whether or not he's been evaluated?
Looks like he's still waiting. That's what it says.
I can file a motion to withdraw the evaluation. I think it was because generally if a client refuses to see me, I don't know what's going on. And so it's usually my next automatic step. But I think after speaking to him, I don't have any question about that.
All right, so then what we'll do is, when are you going to file the motion then to have that withdrawn?
I can do that today, Judge.
Okay. So let's come back on the 23rd, and if you speak to the coordinator and Judge Roman's court, they'll put it on the docket ASAP.
Okay, excellent.
All right, Ms. Ferguson, we're gonna have Davis come back on the 23rd.
Okay, I'm just gonna go say it. I'm not gonna. It was just updated and he had a second job.
Okay.
Have a psych eval done or? No.
No, they just sent over the.
Just, I think I'm
Oh,
getting
you know,
some-
I'm sorry, not, yes, we'll come back on the. How long is it gonna take you to, you said you'll file a motion to have it withdrawn?
Yes, sir. Don't take care of that today.
Okay.
I gotta look at which cases he had picked up when I originally filed all of them.
All right, then we should be able to take care of the plea. Do we have room for her on the docket on the 23rd for a plea? Okay, so June 23rd.
I'm glad you found that because that may pose an issue to do the plea tomorrow.
Yes. All right, so we'll see you then for that.
Thank you, Judge.
You're welcome.
Apparently, I think somebody did, I told, I do my file, it's like, yesterday.
Okay.
So I know it wasn't like, I was like, wait a minute, what are you talking about?
Can you have Mary come back because she still have eyes of Chavez?
Morning, Judge.
Morning.
Happy Flag Day.
Yes, happy Flag Day. Did you speak with the state regarding?
I
this one?
did, Judge. They need to check with their higher ups, and then they'll get back to me on that.
All right, thank you. So just let us know when you want it set, okay?
Will do, Judge. Thank you.
You're welcome. No, what is the status on 2022 CR 1798? When is that set next?
Okay.
Oh, okay. Oh, okay, I guess another judge did it because there's no volume on this sheet. Oh, okay. All right, well, that can go back. And then can you have them pull this file for me? Thank you. All right. Is there Jose Sanchez present?
Yes, Your Honor.
All right, have you conferred with the state? All right, thank you. Rosa Tovar. All right, just remain seated there. Edward Gill.
Judge that, we're working on it.
All right, thank you. Julius Clayton. Thank you. Danielle Gomez. Danielle Gomez. Sorry, can you still have a file on death now? Let's see that. Yes. Do this. Yes. All right, where is Andrew Prado? Can you come forward, please? Yes, Mr. Prado, your attorney had a family emergency, so he will not be here today. We are going to reschedule this. Ms. Ferguson, what date? Let's recall it in 2 weeks. All right, Mr. Prado, what works best for you?
30th.
All right, so we'll come back on the 30th and they'll give you a reset form, okay? All right, thank you. All right, Jose Sanchez. Hello. Hi. What's happening with this case?
If we could just set it for a contested hearing, please.
All right. Who is the state on this?
Michelle Hayden.
All right. So defense is requesting a contested hearing.
That is correct. I believe the new cases are pre-indictment CTD cases, but it looks like we have most of what we would need to go forward on that.
And is there a reason that we can't just proceed on the number 5 and go forward?
I'd like an opportunity to get some witnesses for my client.
I'm sorry?
I'd like the opportunity to get some witnesses for my client.
All right, how many witnesses are you anticipating?
I would say two.
Two. All right, Ms. Burgess, can you reset Mr. Sanchez for contested hearing? And Mr. Sanchez, when contested hearings are set, contested hearings go. So I don't do this where later somebody comes back and decides, oh, I'll just plead true. So if it's going to be a contested hearing, then it's going to be a contested hearing. You understand?
Yeah.
All right.
I can do July 11th.
What time?
I can do it in. I can do it in the morning.
All right, so we're going to come back on July 11th at 9 a.m. for a contested hearing.
Thank you.
You're welcome.
I wait too.
You need to get a reset form and then your client is excused. Good seeing you.
You too.
All right, thank you. Oh, I'm sorry, State, did you have a chance to look into Mr. Story?
I did pull up the. It was just the file. Did you have like a report or something?
Yes, there's a request for extension. I'm gonna set it for a hearing because, just so I can speak with him, because they say that he's completed everything.
Yeah, and I think like I told you yesterday, I think the restitution was the more serious thing we were asking for. I know you said he had monies left, but if he did all his classes and everything else, he's been on for a long time, right? And I
Yes.
think it's been like 6 or 7
And I
years.
extended him to pay the restitution, and he immediately paid it.
Yeah.
Well, so there's no objections.
I don't have any objection to that. If he's done everything except for just money to court costs and programs, I'm okay. Or money for the programs, I'm okay with that.
Yes, that's all.
Okay, Judge, I saw we didn't go down this week, but we didn't go up either.
Yeah, we were even
We're
killed.
just
That's
at the
good.
titration point.
Yeah. It's that. Thank you. Ms. Ferguson. On Peter's side, Judge Román said that she can see her today. Yes. All right, thank you. Yes. I've let her know, so I think I've let her know, so I think that she's gonna coordinate with them to, if she is. He will have to do it from inside the courtroom because she's on Zoom, but she's in court. Okay. But call Mary and see if she can go over there now to speak with Judge Román. Okay.
It's a state.
On the side.
All right, who has the phone?
It's a flip phone.
Yeah, if you guys want to answer, yeah.
Oh, you guys found it?
Yes.
I'm sorry, Judge, it's my client's mother's phone. He's in a panic out in the hall trying to go find it. Should be thrilled.
Well, at least nobody, Norma, next time you should pick up the phone and say, we're not returning it. All right, the party's on Mcdelia Salazar. If I have parties approach. So who's the attorney? So today is the plea deadline date. What is happening with this case?
Your Honor, we have received all of the discovery and we have given you the discovery acknowledgement. At this time, the defendant is denying or rejecting the state's plea bargain offer.
All right, Ms. Ferguson, I need a trial date on Mcdelia Salazar. I know I'm mispronouncing your first name. How do you pronounce it?
Mcdelia.
That's how I say it, Mcdelia. I got it right.
Mcdelia. See, I tried to add too many syllables.
You're doing great.
Thank you, I appreciate it. Sure.
I have a vacation letters in. If you wouldn't mind paying attention to that. First 2 weeks of July.
And Mr. Debbie, how many witnesses are you expecting? And not to pin you down, but just so we'll know where to schedule it.
I think maximum witnesses from the defense would be 2.
Okay, and state, how many witnesses are you anticipating?
So the sheriff's page.
Here's a few, probably between 5 and 10.
Okay. All right, so now we know where we need to be.
I mean, I think it's still a week, don't you think? You don't think it's more than a week?
No.
No.
We'll be here.
All right, July 26th will be your jury trial date. Is that the Tuesday or is that the Monday, Ms. Ferguson? All right, so you'll be back on July 25th. And then your actual trial date will take place on the 26th. But we come on the July 25th to make sure everyone has their ducks in a row.
Thank you.
Sure.
Thank you.
And she'll give you a reset form.
All
Thank
right.
you. All right, are the parties ready on Ellen Hernandez? All right, the court is calling 2022 CR 2976, State of Texas versus Alan Hernandez. Can I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Sophia Martinez.
And are you Mr. Hernandez?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor. We have.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding on count 1 and we're going to waive count 2.
Any objections?
No objections, Your Honor.
Mr. Hernandez, I'm going to show you what's entitled court admonishments, the defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more as a third-degree felony? The range of punishment for that offense is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Make sure you speak up, okay? The court reporter has to hear.
Yes, ma'am.
All right, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine? Excuse me, just 1 second. Hi, excuse me, Deputy, could you move them down that way so Brenda would have an easier time hearing? All right. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Hernandez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count one. Your punishment is to be assessed at 4 years in the prison. There's a $1,000 fine probated, and the state recommends community supervision. Did you understand that to be the plea bargain agreement from the state?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 150 hours community service restitution. You to follow the recommendations from the TAP evaluation, DWI intervention, VIP live, 2 years Texas driver's license suspension and admission interlock for half the term, and a 10-day jail sanction. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge. State office states exhibit 1 in all attachments.
It's been reviewed, Your Honor, and we have no objections.
Mr. Hernandez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, judgments, and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, Mr. Hernandez, he works for J&S Produce, Judge, as he does sales for them, making about $600 weekly. He also has a second part-time job that he does retail sales at Tommy Bahama. He pays child support for his daughter, and he also will be paying her college because she's starting St. Mary's University in this fall. She just
Oh, that's
graduated.
expensive. I think you and I both know that.
Yes, ma'am. And he will be paying for that starting this fall. So he has 2 jobs to try to do that. He also helps support his 78 and 79-year-old parents who live in Lubbock. So he is working really hard to try to stay in compliance, Judge, with everything he needs to do. He is asking the court to follow the probation and to grant him the 4 years probation and follow the plea bargain agreement, Judge.
All right, I normally don't do this because we have COVID, I do. With regards to the 10-day jail sanction, you can either serve that 10 days in custody and be done with it, or either I'll put him on GPS. And if he expects to work during the time he's on GPS, then he's gonna be on GPS for 30 days and he'll only be allowed to work.
Okay, Judge, I
Or
think,
he can do 10 days in the Bear County Jail.
all right, so the court's not gonna hold that in abeyance, you're gonna, okay. Do you want to do 10 days in jail, or do you want to do the 30 days on the leg monitor? She'll allow you, the court will allow him to work,
Yes.
but when you're not working, you have to come home. You have to pay for the monitor. I think it's better than you sitting in jail. You didn't want to sit in jail, so I think.
All right, this is what the court is gonna do. It'll be 4 years in the prison, suspended and probated for 4 years, $1,000 fine, probated. $150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's to be a TAP evaluation, plus follow recommendations of TAP. Counsel, if TAP recommends inpatient treatment, you can always come back and we can have a hearing on that.
All right, Judge, I will.
I want him referred to felony drug court first. There should be the DWI intervention, VIP live, 2 years Texas driver's license suspension, ignition interlock. And I know there's a request for ignition interlock for half the term, but I'm going to say ignition interlock no less than half the term. And if you want it removed at half term, then I will consider it. In lieu of 10-day jail sanction, our defendant is to do full GPS, I'm sorry, partial GPS. He's allowed to work for 30 days. There should be regular reporting by Zoom or in person. I'm going to want field visits 2 times per month, random for 6 months. And there should be random, well, regular UAs. Proof of employment. Within 30 days. There should be no employment as a home health care provider or with minors. Probation, is there anything else that Mr. Hernandez needs?
No, Your Honor, for the drug court, do you want me to do that before all of the recommendations of the TAP?
Yes.
Okay, thank you.
All right, is there anything else you need from the court in order to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review this document with your attorney, Ms. Martinez? Did you review this document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I
All
do.
right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Hernandez, obviously you have an alcohol problem, and you're one of those people who are in that group who cannot drink and just stop at one drink. This is what I've discovered in my time as a prosecutor and defense attorney, and even as a judge. What ends up happening is people who drink alcohol and are driving intoxicated, when there's an accident that happened, they're just fine. What ends up happening is they hit somebody who's just on their way to maybe bring home dinner home to their wife or their children, or either they hit a child who's just trying to live their life, and then they come into court, they boo-hoo and cry because they didn't intend to get in a car drunk and hit somebody. Nobody ever intends to do it, but it ends up happening. Don't be that person who's driving around intoxicated and hit someone. While you're on this probation, you're not allowed to drink alcohol at all. And don't do this thing where you come back to me saying, oh, I had some gummies and I'm testing positive for marijuana. That's not allowed either. You understand?
Yes, ma'am.
So if you want to be in your daughter's life, right, without being in prison, you're gonna have to stop doing these things. And I know your daughter has been accepted to St. Mary's. She's gonna have a great time, but an expensive time. And what I do know is that sometimes people want to celebrate milestones, and they always think alcohol is a way to celebrate milestones. You can't do that. You can't take a drop. I don't drink alcohol, and it's not that I'm, trying to be sober. I just don't think it tastes good. And people said, Stephanie, you need to acquire a taste. I'm like, why am I acquiring a taste for something? Nobody ever says acquire a taste for broccoli. So you need to start acquiring a taste for broccoli and asparagus. All right. Now, felony drug court is a good program. It's a hard program that would benefit you immensely. So don't be dishonest with them, because if you're dishonest with them, what's going to end up happening is they're going to send me a notice back saying you were not accepted because you don't have an alcohol problem. And obviously you do, because this is not your first DWI, okay? And when you go to felony drug court and you complete it and you're ready for graduation, they will let me know, and you can send me a letter. I'll show up to your graduation. All right. All right. Probation is going to speak with you. Just remain in court and they'll go over conditions with you. All right. Thank you.
Thank you, Judge.
You're welcome. Yes. Always good seeing you.
Thank you.
And you can tell them how expensive it is.
Yes.
Please, how old is he? That's right. Thank you, ma'am.
All right. Ms. Abrams, we're doing another plea, but there's no application. You're welcome. All right, could I have the parties on Alejandro Nuncio? All right, am I pronouncing your last name correctly?
Yes, ma'am.
All right. Court is calling 2022 CR 3999, State of Texas versus Alejandro Nuncio. Could I have parties announced for the record for the state,
Brian Grimmer for the state of Texas.
for the defense?
Adam LaHood for the defendant.
And are you Mr. Nuncio?
Yes, ma'am.
All right, defense, I'm going to show you discovery acknowledgement. Have you received all the discovery in this case? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Nuncio, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Nuncio, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft under $2,500 enhanced? That's a state jail felony. The range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
I plead no contest, ma'am.
No, but did you intend, I appreciate that, but did you intend to give up those rights and enter into a plea bargain agreement?
Yes, no.
All right. Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both, Judge.
Mr. Nuncio, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, no,
Has anyone promised you anything other than the plea bargain agreement to get you into this plea?
no, no.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
All right. According to the plea bargain agreement, your punishment is to be assessed at 8 months in the state jail facility, and there are no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Judge.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then to the offense is charged in an indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge. State would offer State's Exhibit number 1.
No objections, Judge.
Mr. Nuncio, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Okay, both parties. I don't have the 2021 case or the county court case.
The judgments?
Yes.
Okay, let me see if I can round them up, Judge.
All right, thank you.
Something was missing.
Yes, Judge Art.
She's pulling the judgments off of file 360. Without objection, would the court accept this, which has the case numbers and the conviction data?
Yes.
Okay.
No objections, Judge.
All right, we're gonna go back on the record. Sorry. We're in one of those coughing fits. I did take my allergy medicine this morning, so. All right, we are back on the record. State?
Yes, Judge. State would offer this single piece of paper to supplement State's Exhibit number 1.
No objections, Judge.
All right, then that will be admitted. After reviewing State's Exhibit number 1 with the supplement, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, and we'll waive PSI.
All right, anything you wish to say on behalf of your client?
Your Honor, we would just ask the court to please follow the plea bargain, which he has struck with the district attorney's office and all matters. I think he just wants to do his time and be able to put this behind him.
All right, the court will follow your agreement. The court, as previously stated, is finding you guilty. The court will sentence you to 8 months in the state jail facility and give you credit for any time served. Showing what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, just one moment off the record. Caroline, can you make sure that this is actually stable with this? Also, back on the record, also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak with an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Nuncio, how old are you?
I'm 29 years old.
All right, you're 29 years old. I've looked at the stipulation by the state, and I understand that there may be drug issues that are involved and other issues that are going on. If you don't make a change in your life, one, let me tell you what's my prediction. All right, I hope it doesn't happen, but this is the prediction. You're either going to end up ODing or something on drugs, right? Because people who make drugs, they're not concerned about getting FDA approval because it's not FDA approved. They're not concerned about the person who's consuming it. They're just trying to get their money and sell it. Do you understand?
Yes, ma'am.
And if you continue picking up these theft cases, what's going to end up happening is you're going to find yourself listed as a habitual. And then you're going to be looking at prison time, not state jail facility time. And then you could probably end up with 20 years. And someone may look at this and say, we're done with you. There's nothing else we can do for you. We're going to send you to prison for 20 years. So of your 29 years on this planet, how much time have you spent locked up? And that means Bexar County Jail or any kind of jail or any kind of prison. How much time?
Like 6 months, maybe more.
No, it was more than that because you have a prior that's a felony.
About a year.
It has to be more than that. So how, let me see his file again, please.
I think the previous was a state jail theft, though.
He also has, this, I believe, a state jail less than a grand.
Oh, yeah, true.
Been in custody since January of this.
All right. So you've done 6 months on a possession case. You've done 6 months on a theft case. You've done 18 days, you've done 17 days, and now you're doing 8 months. And when you think about it, that's a lot of time to be taken out of your life where you don't have a freedom to do what you want to do. You understand?
Yes, ma'am.
And if you continue on the path that you're on, you're going to find a majority of your life is spent in and out of custody in prisons. You understand?
Yes, ma'am.
Do you have any children?
No, ma'am.
All right, well, that may be a good thing because you need to get your life together. And I don't think anybody who starts school in kindergarten, they're thinking, oh, when I grow up, I want to spend a majority of my time in custody. Or when I grow up, I want to be a drug addict. Or when I grow up, I want to be a person who steals. So you got to get it together. Otherwise, it's not going to end well for you, okay?
Yes, ma'am.
All right, good luck to you.
Thank you. Your Honor, thank you, ma'am.
You're welcome.
May I be excused?
Yes, maybe excuse. All right, who are the parties on Rosa Tovar? All right, it's always great to see you. Mr. Sawyer?
Morning, Your Honor.
Good morning.
Tovar, this is the judge of the PSI, okay? Speak now, this legal statement.
So this is a sentencing. Brenda, you ready?
I'm ready.
All right, the court is calling 2021 CR 9160, State of Texas versus Rosa Tovar. Could I have parties announced for the record for the state,
Ryan Grimmer for the state of Texas.
for the defense?
Michael J. Sawyer.
And are you Ms. Tovar?
Yes,
All right, we're here for sentencing. The state, according to the plea bargaining agreement, is proceeding on count 1, which is possession with intent to deliver 4,200 grams. Punishment is to be assessed at a cap of 7 years. There's a $500 fine. State is opposing your application, and they're taking in consideration NIMAC number 650864. Have parties had a chance to review the PSI report, state?
Yes, Judge.
Defense?
Yes, Your Honor.
Any objections to the PSI report and the TAP evaluation, state?
Yes, Judge, we've read both.
All right, any objections?
No objection, sorry.
All right, that's a problem.
We
Defense?
reviewed it. It's factually correct, Your Honor. We have no objection.
All right, state, do you have any witnesses?
We do not, Judge.
Defense, do you have any witnesses?
Only Rosa Tovar who would like to address the court on her own behalf.
All right, Ms. Tovar, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you speak up. What is your name, please?
Rosa Tovar.
All right, defense.
Thank you, Your Honor. Rosa, this is your one chance to address the judge on her not okay. You're asking for a long shot. You're asking for probation, knowing you have a long criminal record, right? You've been in prison before. This is your one time to tell the judge, what is it? What is your change in plans in your life that perhaps you benefit from probation? Most importantly, when were you released from prison? What year?
2016
And what was that for?
burglary.
At the time you went to prison, you had many prior arrests for thefts and various assorted charges. You tell the judge, how long were you a drug addict?
Say it again.
I was on drugs for about 10 years.
And how old were you when you first became drug addicted?
I was 19. 18.
And you picked up a variety of theft charges. Why were you stealing back in that period of your life?
To support my habit.
And eventually got you in prison. You were released about 2016, right?
Yes.
Can you tell the judge, have you used any drugs since 2016?
No, I've been clean 7 years as of last month.
You know the charge you're facing today. you tell Judge Boyd, do you have any children? And if so, how old are they?
I have a 2-year-old boy and a 1-year-old girl.
And currently, do you live with your mother?
Yes,
And in the event you were sent to the penitentiary, who would be left to care for your 2 children?
my mom,
And how old is she?
57.
Does she work or is she on disability or something?
She doesn't work.
Could you express to Judge Boyd why now in your life do you want to make changes? Why do you think this time you'd benefit from probation instead of going to the penitentiary?
Well, I have my kids now, and I think probation will help me work.
In terms of work, what kind of work would you like to do? What are your goals in that area?
Well, I'm not sure. I've been looking for a job online to do like something on the computer, but it's hard with my record.
Once you've got a criminal record, it's hard to go on down and apply for a regular job. You found that out. So what you get are low paying, fast food jobs, things like that. Would you like a chance to receive some training or education that help you enter the job force and get a job that'll pay a good wage to support your children?
Yeah. My mom was telling me I could go back to school since I got my GD in prison and stuff.
And what would you like to study at school? Something along the electronic computer lines?
Something like that.
Is there anything else that I tell Judge Boyd this morning before she has to make a decision in your case?
Oh, just that, I mean, I've changed my life since 2015. I haven't done any drugs, and I mean, I'm just trying to raise my kids to be right.
Is that all you have?
I know, yes.
I will pass the witness.
Ms. Tovar, in this case that you're before the judge for, you told the PSI officer that it wasn't your drugs that were in the purse. Is that correct?
Yes.
Okay. Do you know what the 2 types of drugs were that were found in your purse?
Meth and heroin.
And when you went to the PSI officer to talk to them about your drug history, what did you tell them your drugs of choice were back in 2015 when you said you stopped using?
Heroin.
Okay. Did you also tell them you use meth daily?
Yes, but it was mostly heroin.
No further questions.
Nothing further, Your Honor.
All right, I have a question. So I read, of course, the stipulations in the PSI report. Which child was it in the vehicle with you where these drugs were found?
My daughter.
And how old was she at the time?
She was like 8 months.
All right. And when you're drug tested today, what are the results going to be?
Negative.
For everything?
Yes.
All right. I'm not saying what I'm going to do yet, but I would like to see her do a drug test today. Probation, can we get a drug test?
Yes, Robert.
All right. We're going to come back. We're going to do a drug test today.
Okay.
Do you need any water?
Yes.
All right.
Judge,
we're
can
gonna
I
have
go into the court and come back?
Yes, we're going to have you remain in the courtroom. Could you get your client some water, or I think there's a water fountain in the hallway.
I'll bring some water from downstairs.
All right, thank you.
Thank you, Judge.
And Mr. Sawyer, she surveyed in the courtroom. All right, the court is going to call 2020 CR 3692, State of Texas versus Edward Gill. Can I have parties approach? All right, could I have parties announced for the record, please, for the state?
Michelle Hayden for the state.
Johnny Cisneros from Mr. Gill.
And are you Mr. Gill?
Yes, ma'am.
A defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have your,
Court will find that the state is in compliance with discovery. Mr. Gill, I'm showing you what's entitled application for deferred adjudication. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
we do, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. I actually filed a motion to amend the indictment this morning and filed it with the court. It may still be in the back, though. I can run and grab it if you'd like.
Yes,
It's
I
a-
have your state's motion to amend indictment. Any objections to the state's motion to amend the indictment?
No, ma'am.
Then the motion to amend the indictment will be granted.
And we will be proceeding on that amendment, which is now count 3 in the indictment.
All right. Mr. Gill, do you understand that the state has amended your indictment to include account 3? And your defense attorney has no objection
Yes, ma'am.
to that? Do you understand?
Yes, ma'am.
All right, we're gonna take just give me 2 minutes. And could I have us on mute, please? Somebody in their phone, I tell you.
Judge, can I?
Yes.
I have a magnetic dismissal. for you. And then this is for Charles Bunk's client because he's out of town and Megan dropped it off for him. He's asking to go on vacation.
And so do y'all have any objection?
We don't have any objection. He just has a lot of history. So we're not necessarily agreeing. We're just going to defer to the court.
All right, I will look into it.
Okay, good.
Thanks. Yes.
Can I just ask you, time wise?
Yes.
On Richard Thomas, if we do go to trial on that case today, is it your intention that we put on some evidence this week or that we'd be able to put on? Because 4 witnesses, I think, from the state.
All right, that would be this.
This is the one where you said you were gonna put on, you allow us to put on witnesses.
Next week?
Mhm. I don't know if we could just put on all of our evidence next Tuesday, if we were to go on this case.
All right, let me think about that for a minute.
Okay.
Judge, I do have a motion on that confession, so that the confession that he tried to get the witness who cannot be here. I do have a motion on that.
Oh, we'll hear before the witness testifies.
Okay.
Sure.
Thank you, Judge.
You're welcome. I'm just doing these two. Ms. Tovar, the court is taking its break at noon, so you need to provide me with that UA in 5 minutes. Do you understand? All right, and we're ready to go on Mr. Cisneros' case. Brendan, you ready? All right, so we're back on the record in 2020 CR 3629. And I believe where we stopped, the state had a motion to amend the indictment. Is there any objections from the defense?
No, Your Honor.
All right, Mr. Gill, you understand that the state's amendment of the indictment is a substantive change? Do you have any objections to going forward on the amended indictment, which includes count 3? I'm sorry?
No, ma'am.
And defense, are you waiving your right to object to the amendment of count 3?
We are.
All right, and Mr. Gill, again, just so the record is clear, you understand that count 3 is a substantive change from the indictment. Do you understand that?
Yes, ma'am.
And that the count 3 that the state is adding, you have no objection to it?
Yes, ma'am.
And defense, are you waiving your right to prepare for trial because the state's motion to amend the indictment for court count 3 was presented to the court today? Are you waiving your time?
We're waiving our time, Your Honor.
All right. Then next, Mr. Gill, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand that the state is proceeding on count 3, which is an injury to a child? Did you understand that?
Yes, ma'am.
And they are proceeding on that count as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand that?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Gill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 3. There's a $1,000 fine. The state is probating $500 of that. The state recommends deferred adjudication. There's an affirmative finding of family violence. They're asking that you follow any recommendations of the TAP evaluation, parenting classes, the MRT course, no contact with Emity, EMITY, Gill, Noreen, NOREEN Sanchez, Matthew Gill, and Adeline, ADELYN Gill. Did you understand that should be the plea bargain agreement?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 4 years and every 120 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, count 3, injury to a child. How do you plead guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers States Exhibit 1, its attachments into evidence.
No objections, Your Honor.
Mr. Gill, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding the guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We can, Your Honor. Yes, ma'am.
All right, and state, is the complainant aware of the outcome of this case?
I believe so. I texted Marina earlier today.
All right, anything you wish to say on behalf of your client?
Well, yes, but I think there's something that I need to address maybe before. I'm
Yes.
not sure. I might have overlooked something on the paperwork. The amendment should say reckless injury to a child.
That's what it says.
Okay, then there should be no affirmative finding of family violence if it's reckless, is my understanding, because I don't recall seeing anything about affirmative finding. If it's reckless, I don't know how it would be an affirmative finding.
Judge, I'd included, when I wrote down the offer, I included affirmative finding family violence. I may have put AFFB.
Yes.
I mean, we can leave that determination up to the court, but it was included in the offer in the paperwork.
That's true, it was, okay,
Yes.
you wrote it at AFFC.
Yes,
And I
so it's in
overlooked it
the plea bargain agreement.
I overlooked it in that respect, in that I should have realized that it was a mistake on my part, because if it's reckless, how can it be an affirmative finding of violence?
Yes.
So I think we either need to take that off by agreement or or withdraw a plea or something, because if it's reckless, again, I'm going to repeat myself. How can it be an affirmative finding of family violence?
State.
Judge, I thought it was part of the agreement. Again, on the paper where I've written down the offer, can you just give me a
Yes.
second to talk to?
Yes, it isn't, and just so the record is clear, it is in the plea bargain.
It
agreement.
is.
All right.
I'm agreeing to that I overlooked it. It was initial, it was not spelled out, and I just overlooked it for
No
one reason.
problem. I'll let y'all discuss it.
Okay, thanks.
Sure. Yes. Yes, Mr. Sorry.
We will not need that test of Ms. Tovar because she will fail it.
Okay. All right, thank you. And we'll take that matter up, just as I finish with this.
Okay.
That's fine.
All right, so with the affirmative, we're back on the record with the affirmative finding of deadly weapon.
Family
I'm
violence.
sorry, affirmative finding of family violence. I'm reading something as I'm doing this. Yes.
Judge, since it appears that defense overlooked it on the offer I wrote down and then again on the plea paperwork, and there was apparently no agreement from their mind, we're willing to waive that in this case, but we would ask for no firearms.
Okay. And if you
And
all
I'm in
would like-
agreement with that.
All right, if you all would initial that, please, as a part of your plea bargain agreement, that it's being removed from the plea bargain agreement.
Yes, ma'am. And I'm so sorry to take the court's time on there. That
No,
was.
I'm here.
Mhm. Off the record, may I request something from the court?
Yes.
Can you ask them to change the cameras, because it's making me look fat?
That's my hideout over here.
Where do I initial
Well, you
anywhere?
know what? I think it's adding like, we're just gonna pretend like it's adding 60 pounds.
I
to
mean,
everybody. So-
I know I'm pleasantly plump, but
All right, so we're back on the record. Is there anything you wish to say on behalf of your client?
no, ma'am, other than to please follow the plea bargain agreement.
All right, Mr. Gill, are you employed?
Yes, ma'am.
What do you do?
Force pressure control, we're gonna live through it.
All right, this is what the court is going to do. There's $1,000 fine that'll be probated. Is Child Protective Services involved? Does anyone know?
No, ma'am, they're not.
All right, 4 years deferred adjudication, parenting classes, no contact with the following persons.
That is something, another thing I'd like to address. And that was to be left open to the court. When you finish your part, Your Honor.
Okay, no contact with Emily Gill, Noreen Sanchez, Matthew Gill, Adeline Gill, No firearm possession. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. The remaining hours will be waived once you complete parenting classes. We're just going to do regular UAs, or we can do the drug patch, because I know you say that he works.
He's
And they're all
tested
good.
regularly, Your Honor.
Yes. So we're gonna do regular UAs, drug patch. If there is a positive UA probation, then we'll do a TAP evaluation. There's gonna be regular reporting by Zoom or in person. Proof of employment within 30 days. No employment as a home health care provider or with minors. I'm gonna want field visits one time per month for 6 months. If there are no issues, then we can cease with the field visits. Probation, is there anything else that he needs?
No, Your Honor.
Mr. Gill, is there anything else you need from the court in order to be successful?
No, ma'am.
All right, and there's something you wanted to address, Mr. Cisneros?
Yes, Your Honor, on the kids, Matthew and Adeline, we're asking for supervised visits on those. So he wants to have visitation with his children. We just want supervised visits to protect ourselves.
All right,
More so
if-
than anything else, and so he can see his other children.
All right, once he's done a parenting class and once I have an acknowledgement from, I guess, was there a CPS case that was ever opened?
We have, yeah, we've got CPS records, but I don't think it was related to this incident. I told Mr. Cisneros we'd go open on this one. The mother, Noreen Sanchez, does not want him to have contact with the other two kids. So state is asking for no contact of defense.
All right, so what we'll do, once he completes a parenting class, and then we're gonna have documentation what CPS did with this case, then I can make an informed decision on whether or not he should have visitation.
Yes, ma'am. Thank
And
you
I
so
don't know
much.
if it was been done, but I don't have a trial court certification of defendant's
You know
rights. to
what? I
appeal.
don't believe I got
All right, if
that.
you
I'll
could do
get
one
it.
for me, please, and then we could finish.
I'll
this.
do it right now.
All right, thank you.
What happens when you get old?
I'm already there, don't say that.
This is- Your Honor, it's been signed. I'll submit it to the court as soon as I fill it out.
All right, thank you. So, Mr. Gill, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Tovar, good luck to you. I'm sorry, Mr. Gill.
Thank you, ma'am.
See, I'm doing like 30 things. There are 30 things happening.
Let me finish.
All right, thank you.
Okay, sit down.
Okay, thank you. All right, on this one, just when we had you the trial court certifications, if you would like to. Danielle Gomez. Where is this Gomez?
She's not here yet.
All right, just give me a moment. We're gonna put that on the record. Julian Martinez or Julian Martinez? All right, where is Julian Martinez? Okay. And where are we on Mr. Martinez's case?
Judge, he's got 2 indicted cases. He's got several unindicted cases. The state reached out to the detective at the beginning of this month, informed the detective there's some things that they need from him for us to get an offer and move forward. And so we're still waiting on that.
All right, Mr. Martinez, can you come forward, please? Okay, so what discovery, what unindicted cases? Is this the thefts of firearms?
Yeah, Judge, she has several theft of firearms awaiting indictment. An email was sent from our intake attorney on June 9th to the detective requesting the missing discovery on all of the cases. So I would expect that would be turned over pretty quickly after that.
So what is the anticipation of the disposition of this case?
I'd like to work out a deal, Judge, but obviously the state's not in a position to make an offer yet. But if we get this reset no more than 2 weeks, I think that keeps us, fresh in the rotation. And I'm hoping they get that, so Brittany and I can get that resolved.
All right, state, when do you expect you'll have this information on the other cases?
Hopefully soon, Judge. I don't know the turnaround time for that detective, and it was the intake attorney who emailed him. But she's quick at getting it uploaded once we receive it.
All right, so Ms. Ferguson, on Julian Martinez, I'm going to give you all a 30-day reset.
Okay.
And you all need to work on this off docket and submit them an offer off docket, and then we'll see where we are on in 30 days.
And we're hopeful that we'll get it worked out.
All right, so we're going to come back on July 18th.
Thank you, Judge.
You're welcome. Just get a reset form from Ms. Ferguson.
Yes, ma'am.
Yes.
Judge, I always enjoyed like the dynamic in here, because it's like this wall full of other dudes. And
Oh, you're so awesome. See, I know what you're saying is true because you already have your reset.
yes. But if anything come in, you feel free to tell them I said that.
Okay, I will. All right, Tovar. And then after Tovar, I'm going to take up Danielle Gomez. Caroline. All right, we're back on the record in 2021 CR 9160, State of Texas versus Rosa Tovar. My understanding is that Ms. Tovar needed to take a drink of water before she did her test. And I was informed that you don't need a drink of water. So what's going on, Ms. Tovar?
I had a miscarriage last week, and I used med.
All right, so now we're coming up with new information. All right, is there anything else from either side?
Not from the defense, Your Honor.
No, Judge.
Okay. All right, the court's going to deny your application. The court will find you guilty, and I believe the previous judge who was here previously found you guilty. Does anyone want to speak to the cap of 7 years?
You're on the cap being 7. I just asked the court to consider whatever the court considers a fair sentence this morning. That is all.
All right.
Judge, I believe she's had a number of offenses of a similar nature. In addition, this offense was occurred with her child in the car. We're asking for the cap of 7 years on this case.
All right, I will sentence you to 6 years in the prison, give you credit for any time served. There's a $500 fine, time and money to run concurrent. Taking consideration night bag number 650864. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? You understand? Yes. All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Ms. Tovar, if you would like, I can ask that you be referred to the therapeutic community. The therapeutic community does not increase your time. I have no power to force them to place you in the therapeutic community, but I do know if you don't ask for it, you definitely will not be placed in it. So the therapeutic community is to help people who may have drug issues or whatever issues they may have to help them, hopefully, when they're released, be on the right track. Would you like to be considered for the therapeutic community? All right, and so we will do the therapeutic community. All right, we can go off the record. Ms. Tovar, you have young children. And people, I don't know what's wrong with people. They believe that they can have children and children can raise themselves. They cannot. They're dependent on you. So you're supposed to be raising your children, not their grandmother. Their grandmother is just there, supposed to be there to spoil them. Now she can't do that because you're not holding up your responsibilities. Do you understand?
Yes, ma'am.
All right, good luck to you.
Just all I have my excuse.
Yes, thank you.
Have a Good day.
All right, the court is calling 2022 CR 4510, State of Texas versus Danielle Gomez. Could I have parties approach for the record for the state? Can you take this?
Oh, it's me, Judge. Ryan Grimmer for the state of Texas.
For the defense? All right, this hearing is scheduled at 9 a.m. It is now 12:11 p.m. I'm sorry, everyone. Where is your client?
She's not here.
Do you have any idea where your client is?
I have no idea.
All right, Deputy, could you, no problem. All right, state.
Yes, Judge. State would make a motion for bond forfeiture.
All right, that will be granted. Your client will be remanded without bond. If you're able to get in touch with your client and she presents herself, the court will reconsider.
Will do. Thank you.
Thank you. Brenda, are you okay to finish a couple of pleas?
If I can just run to the back for a second.
Yes, are you okay? Okay, yeah, no. What is happening on Priscilla Sosa? All right, what is happening? Where is that Miss Sosa?
Yes.
Come up.
You want her up here?
Yes.
Okay, cool.
What is happening with this case? We were here last time for body cam and Coban.
Judge, and we requested all videos associated with the case. They responded that there are no videos available. And then today there was a form that says there's cell phone video of the search warrant. And I sent the video, or I sent the request for that video for defense counsel this morning.
All right, Ms. Ferguson, I have a 30-day reset on Priscilla Sosa, please. All right, we'll come back on July 18th to make sure we have that video for you. All right, just get a reset form from Ms. Ferguson.
All right, thank you.
You're welcome. And so we just have one plea left. And then we're going to take a break. So the last case that we're doing is Crispin Valle. And then we're just doing one more case.
Judge, may I be excused?
Yes. All right, court is calling 2022 CR 4264, State of Texas versus Crispin Valle. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the defense?
Megan Enriquez for Crispin Valle.
And are you Mr. Valle?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Valle, showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I believe we are, Judge.
Mr. Valle, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I believe he is, Judge.
Mr. Valle, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? And did you, did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the state jail facility. Cause numbers 2022 CR 4265A, 2022 CR 4623, and county court cause number 672388 is to be dismissed. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence to support the defendant's guilty plea?
State would offer State's Exhibit number 1.
Any objections?
No, Your Honor.
Mr. Valle, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we just ask the court to respectfully follow the plea agreement that we reached with the state.
All right, the court will follow your plea bargain agreement, sentence you to 1 year in the state jail facility. The court will take in consideration 2022 CR 4265A, 2022 CR 4263, County Court Cause number 672388. Is there anything else from either side with regards to sentencing? Mr. Valle, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have a court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, Mr. Valle, it appears that you have a drug problem, and it appears that you can't solve it on your own. If you would like, I could refer you to the therapeutic community. I have no power to force them to place you in the therapeutic community, but it will not extend the length of time that you're in custody if you would like to do that. All right, good luck to you. Do you have, we're off the record. Do you have any children? Okay, well, that's a good thing. You gotta get your life in order before you do that, okay? All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, everyone, we're gonna take our break. We will be back at 1:30-ish. Brenda, I'm putting the ish on that, the ISH, so that'll give everybody